to interfere with the documents I'm submitting at the moment. In order to complete the chapter of the skeletons of Strasbourg, it seems that the skeletons were supplied, or to be more correct, the people to keep this skeleton factory going were supplied. How and by whom, we do not know. But we do know that when the Allies entered Strasbourg, the SS men were worried what to do with those skeletons, and especially what to do with the corpses of those men whom they had no time to turn into skeletons but were killed for this purpose. The flesh did not rot yet. We have a document number 914. Of the 5th September 44. Sievers writes to Brandt. In accordance with the proposition of the 9th February 42, gives the reference number which is before the court. SS Sturmbannführer Professor Hughes was ordered to collect skeletons. Because of the scientific work, the job of the skeletonization was not completed, considering the time needed to collect the bodies in the anatomical department. Instructions are required in connection with 80 pieces, as he calls them. He can deal with the removal of the flesh and thus efface the identity of those people, but all this work will be in vain and will mean a loss to this very special collection.
President of Court, he says a considerable scientific loss. That's what he said, a großer wissenschaftlicher Verlust, a considerable scientific loss.
Mr. Hausner, the hominid, an expression he cannot translate into the Hebrew, the collection itself draws no special attention. There are soft parts which were created. They look as though they are remnants of old corpses collected and being handed over for cremation. The question is to turn all of them into skeletons and say it is an anthropological collection. It does not raise any suspicion. But if soft parts remain, the Allies coming into Strasbourg may be told that these are remnants of old corpses from 1940, before the Germans entered Strasbourg and are being taken for cremation.
Exhibit T 1368.
But they did not have the time to efface the traces. And when the liberating army came into Strasbourg, they found these corpses. We have the testimonies from the cases against Karl Brandt and others who were accused in connection with this collection of corpses. 1050 is the testimony of Henri Pierre, a Frenchman.
Henri who?
Henri Pierre, Henripierre. He worked in Dr. Höst's institute.
Is he a Frenchman?
Yes, a Frenchman working for Dr. Hirth. He was a prisoner and worked for Dr. Hirth. I ask the court to admit this in evidence.
President of Court, Dr. Savatius, have you any comment?
Nein, ich war bei der Vernehmung des Zeugen zugegen und habe keinen formellen Einwand. No.
Dr. Savatius, no. I was present during the interrogation of this witness. I have no formal objection. It will be Exhibit T1369, remarks the President of the Court. President of Court, yes, please carry on.
Mr. Hausner, this Henri Pierre testifies that he worked at this Hearth Institute. He remembers 3 transports of bodies arriving at the institute, still warm. They were Jewish bodies. He noted their tattoo numbers from their arms. The corpses were still identified by the Allies. He identified them when the Allies took them. When he was asked, how does he come to know that they were killed for this collection, and this is his answer: before I came to deal with those 86 bodies, I have already conserved the bodies of Russians and Poles who died because of ill treatment. This is enough to prove that I know the difference between death because of bodily harm and another kind of death. He was a high-ranking officer. He has his own driver. The bodies from the Motzik camp came with death certificate accompanying. These 86 victims had no death certificates with them. The testimony of Sivers himself in this matter, and this is our number 912. I request the court to admit this in evidence as well. Sivers is not alive. I hope that the counsel for the defense will remember this witness. This was also in the same case.
Exhibit T1370. President of Court, Dr. Savatius, have you any comment to this document? Dr. Savatius, no formal objection.
Mr. Hausner. I beg to call the attention of the court to a number of passages. On page 567, we read the following document, NO 116, a letter from Brand to Eichmann. Why then was it necessary to have such a letter to Eichmann, who was no longer the head of a department? He was the head of that department, and Glicks already know the fact. He was in charge of all concentration camps, this Glicks. And this is the answer. Glicks sent me to Eichmann, who until that time I did not know at all. Eichmann had a telephone call from Glicks, but he said that he needs a letter from Himmler for his personal files, and that is how this letter came to be written. Question: what did you discuss with Eichmann? Answer: I handed over the report by Hirth and told him that Hirth's employees, Hirth's workers, want to carry out anthropological researches, and he, Eichmann, was to enable and create the necessary conditions at Auschwitz in accordance with Himmler's instructions. On page 5678, he was asked in regard to Dr. Berger's report, work at Auschwitz, if he received this report. The answer is yes. Berger came back from Auschwitz and said that the work there ceased because there was an epidemic at Auschwitz, and declared that he has to report to describe the position to the head office.
President of Court, not in the head office of Reich Security, but to the head office of Reich Security. Mr. Hausner, yes, quite so, Your Honor.
Our following document, which I now beg to submit, only to identify the pictures of the corpses which the Allies found at Strasbourg on their entry, the corpses supplied for the manufacture of skeletons. This is our number 790. This is an inquiry, an investigation carried out by the commander of Bergen-Belsen camp. Kramer is the name. He is not alive. He was executed. And an official certificate issued by the French police.
President of Court, is there something by Kramer here in addition to these pictures?
This is attached to the investigation of Kramer. They were shown to Kramer while the investigation was being carried on. And for further identification, we have a certificate issued by Mr. Eugène Heldger of the Strasbourg police, the investigation police. This is also identified by the head of the investigation police at Strasbourg. Kramer's evidence is necessary for the prosecution because there is a detailed description.
President of Court, excuse me, this is a technical detail, but we must have control over it. But I see you have a number of pictures on the desk in front of you, and you have Kramer's evidence. What is the link between the two?
Hausner, Kramer killed those people.
President of Court, I understand, but I saw that you, sir, were now affixing the pictures to the document with a paperclip. What is the connection?
No, Your Honor, I shall make two documents out of this batch. But technically, I attach them because it is N0807, and this is how we found them in the Yad Vashem archives. Kramer's testimony, the French confirmation, and the pictures were all in one document.
President of Court, is there any marking on the pictures themselves?
There is a description of what is shown in the pictures and a confirmation. There is the description of 21 pictures. As far as we have here, the confirmation is given by Mr. Bar Shalom of the Yad Vashem Institute. He swore here before this court in regard to the authenticity of these pictures, and these were included in the documents he confirmed.
President of Court, let us take them separately then, if there is separate authentication.
If it pleases Your Honor, yes. This is Kramer's testimony before the American military court. Mr. Hausner, I beg to apologize. This is the investigation of Kramer at Strasbourg.
Was an exhibit in the Brandt case.
It served as an exhibit in Brandt's case.
President of Court, the Kramer testimony, that is the document.
In
the physician's trial, yes?
Yes, in the case against the physicians.
That will be Exhibit T1371. President of Court, I assume that we have tacit agreement from Dr. Servatius since he has made no remarks. I can always turn to him, but I am assuming this is agreement, tacit agreement. How about this particular document, Dr. Servatius?
Ich habe diese Erklärung von der französischen Richtung gesehen und auch die Bilder. Ich habe keine Ahnung.
Dr. Servatius, I have seen the affidavit of the French judge and also the pictures, and I have no objection. It will be Exhibit T1371, as I said.
Mr. Hausner, now the confirmation by the French police officer in French, a translation into the English, and a detailed list of the pictures themselves, the pictures of the corpses kept in formalin, preserved in all conditions of
decay.
Supplied through the accused for killing for the skeleton manufacturer in Strasbourg. 21 photographs. Judge Halevi.
Judge Halevi, where were they killed? In Struthof?
Yes. Struthof. This is a different camp near Matzweiler. This is not Struthof near Danzig. Struthof was a part of the Matzweiler camp. Kramer describes this in his testimony. I will spare the court from listening to those extremely touching passages.
It will be Exhibit T 1372. President of Court, are they in the same order, the pictures, as they are mentioned in this report?
They should have been in the same order. I asked that the document be prepared in this way. I hope it is so. Now, since there is no objection to admit Rajewski's evidence, I request the court to admit the
President of Court,
evidence.
Professor Rajewski.
He is a professor now. Here, in this testimony, he's only a witness.
President of Court in Warsaw.
Yes, in Warsaw. This is his testimony, confirmed. The passages I beg to underline are in our document 1273, already submitted to court.
President of Court, I think some arrangement must be made here. Judge Halevi, this is 1356.
This morning, yes, Your Honor.
President of Court, we shall call it T1356A in order to link it with a previous document.
Rajewski says that he was arrested on the 10th of May 40 for celebrating the 3rd of May. This was the Polish national anniversary. He was the director, the headmaster of a high school in Warsaw. He was sent to Auschwitz on the 22nd of October 40 and stayed in Auschwitz up to October 44. He worked in the Aufnahmestube of the political department. On page 174, he says, in all that is connected with mass transport, these did not arrive with individual questionnaires, but only lists of the whole transport would arrive. Later, cards with individual names would be introduced. Beginning March 42, transports of the RSHA arrived, and the office had a lot of work in registering those groups individually.
Excess work they couldn't register.
Therefore, an instruction was issued to prepare a stamp, a rubber stamp, and stamp all the forms, including the details in figures. This I beg to submit to court. The card had the following writings: RSHA 4B4A, and right underneath, Jews from France, Belgium, and Holland. 4B4A, 2963/42G/1393, Jews from Germany. 4B4A 2927/42G/10148, Jews from Greece. 4B4A 3013/42G/1310 Jews from Croatia, Jews from the Protectorate, Jews from Theresienstadt, from Romania, from Hungary, from Italy.
יהודים מקרואטיה, יהודים משטח החסות, יהודים מטרזין, יהודים מרומניה, יהודים מהונגריה, יהודים מאיטליה.
Later, 4B4A stroke 39 Jews from GG, this was the general government, and Bialystok. And finally, on the same form, we see Poles, 4B4A, 366/42G/1505, Jews, Poles, Aryans, non-Jews.
President of Court, that is quite inexplicable. What does RB4A have to do with Aryans?
If we read the following sentence, becomes clear. I saw this writing on a form from Zamość, and those people passed through Auschwitz. These are the evacuations of Poles. 4B4 continued to deal with those Poles as the successor of 4D4 department in evacuating the areas from the Polish citizens to prepare their apartments and their facilities for the Volksdeutsche. The Attorney General the prosecution asks the witness, the Polish transports which were to be gassed without any registration, did they have, were they numbered the same way as the Jews? Answer, yes.
President of Court, but I see that this was not resettlement. They were sent to the gas chambers, he says.
Mr. Hausner, yes. I did not understand the question, Your Honor.
President of Court, I remember that at a certain time the Department of the Accused dealt with the resettlement of Poles. But I believe this is the first time we see an argument that he was also engaged in the extermination of Poles, non-Jewish Poles.
Mr. Hausner, we are now dealing with the deportation of Poles. There were also Polish transports which were exterminated, but these were not sent by Eichmann's department.
President of Court, I see.
There were Polish transports sent by Eichmann's department to Auschwitz as a concentration camp.
President of Court, I see. President of Court, you will remember, sir, that we still have to get an authorized translation of this. Again, I see peculiar things here. Prima facie, the translation looks awkward.
Yes, of course, we shall prepare two correct translations of the document. Now I come to a different chapter of the same nature of the chapters we dealt with. This is the matter of sterilization. If the court permits, I beg to... I do not think that we shall sit longer than another half hour, or a half hour more than the time I said yesterday.
Attorney General, I agree, we cannot finish it today. So maybe we shall start with the Sassen document and we'll see where we stand, Your Honor.
Yes, this is a good suggestion, and then we shall see how things develop. This would be a proper thing to follow today. President of Court, you were too optimistic in regard to today's session.
Attorney General, I admit I am behind by about 2 hours or 2.5 at least. Now, according to an expert's testimony, it is Superintendent Chagag. He is here and prepared to submit to cross-examination. He examined all of the reprint of the Sassen handwriting, that is Z-A-A-S-E-N.
In the meantime, this is only for the court to observe.
I merely wish to explain matters briefly. Superintendent Chagag found that this entire reprint consists of material which was printed on 3 typewriters. Partly it is also in handwriting. President of Court to the usher, a technical instruction. Superintendent Chagag divided the material, the typewritten material, for the convenience of the investigation into 16 separate files, and the material which is in handwriting is in another file. It was marked with the figure 7. He also gave running numbers to all pages.
What is bandim?
Band, it's a tone band. It's a tape. This is how it is called in the reprint, tape 1, tape 2, and he followed that order. As I said, Superintendent Chagag found that this printed material was typewritten on 3 typewriters. It is not printed, it is typewritten. Most of them on the second machine, 1 page only on the 3rd machine. On the first 2 machines, most of the material, and 1 page on the 3rd. So for all practical purposes, we can ignore the 3rd typewriter for the moment. He states that all of the material which is in handwriting which comprises 83 pages, is identical with the handwriting of the accused in accordance with an expert opinion already in the files of the court. Actually, 2 expert opinions, one from the 16th of May 61 and the other one from another date. He compared the handwriting which I presented him with from these reprints, these 83 pages, and he found that the handwriting of the accused, that this is the handwriting of the accused, and he referred to a comparison with handwriting which Bureau 06 furnished him. And this is document T36. That is the memorandum of Superintendent Chagag, where he identified the handwriting of the accused. He states that all the material, the handwritten material in file 17, as he calls it for purposes of classification, including 83 pages, all of that was written by the accused. Superintendent Chagag further states, and he lists a number of signs in his expert opinion, that the various corrections in the reprint, both in those parts typewritten by 1 typewriter or by the 2nd typewriter, all of these corrections, and there are 86 such corrections which he can clearly identify. All of them are in the handwriting of the accused. There is another considerable number of corrections about which Superintendent Chagag will testify, that he has data for identification, but he cannot be quite 100% certain in identifying the handwriting. But in these cases, there is no counter-indication about the handwriting of the accused. Now, for the completion of the picture, I'll say that in certain passages, there appears in these reprints another handwriting in a small number of passages, and these are not corrections which change the text, but it is obvious that this is incompletion of certain matters, whether because these are cases where something was not recorded well or the typing was not proper. These are not corrections but completions, and as I said, it is a small isolated number of passages. In order to persuade the court in another way too, that indeed this document is from the accused's own handwriting.
This is a typewritten document with corrections in handwriting.
Yes, some handwritten corrections and 83 handwritten pages.
And all this in photographs.
Yes, all of this is in photostatic form. The name of the accused appears many times in this conversation which develops between himself and this speaker. The speaker is mentioned 3 times. The interviewer, rather. Once in what we call Tonband 12, tape 12, on page 2, he is called Comrade F. On tape 27, page 5, as Comrade Sassen. And on tape 28, page 3, again Comrade Sassen. The first initial should have been S, Comrade S. And Sassen is apparently spelled S-A-A-S-E-N. That was an interpreter's comment.
How is the accused mentioned? How is he mentioned? As present or house?
This is in the course of conversation. He is being addressed as Mr. Eichmann. What do you say about this? What do you say about that? Countless times. Not countless, but many times. It can be counted. The single page, which was typed on a different typewriter, a third typewriter, its only authentication, and I would like to submit this page too, the only authentication is its being an appendix, and can be woven into the context of the existing matter. It fits the what is said in the entire reprint. It meshes with what is said in the reprint very well.
Are they separate pages, or does it continue with another roll?
No, it is the end of one tape, but it follows content-wise from the previous material. The court, if the court wishes to study the material before giving a decision, it transpires clearly that this is all about the same subject. The court will remember that the accused in his interrogation by Bureau 06 confirmed that indeed he had such a conversation, part of which was published in Life magazine, but he claimed then that the passages in Life were taken out of context and from various passages, and therefore this, he claimed, distorts his accurate version. It is out of context, he argued then.
President of Court, on which page in his statement?
The court will find this in Superintendent Lösse's testimony, and the comments of the accused are about this Life magazine matter. This is Exhibit T41. 48, 49. There are 3 exhibits. We shall identify it in a moment. I believe there are 3 different exhibits. He presented his comments to Superintendent Löss on the Life magazine article on 3 different occasions. Therefore, these are 3 exhibits.
This is T47, the comments by the accused T48, and T49 to 51 is an appendix to the very same comments.
Precisely, thank you very much. Now, we did not content ourselves with a formal investigation. We also tried to have an internal comparative test performed. We have a comparison between a considerable number of passages,
President of Court, according to contents.
precisely from the contents point of view. The matters in this document, which we shall call for convenience the Sassen Document, and a comparison with what he said in Bureau 06. That is circumstantial evidence, yes. And the court will find that in a considerable number of passages, the accused repeats in Bureau 06 matters which are in this reprint. I won't say that he always repeats himself. There are divergencies, there are many deviations, but there are typical expressions in reaction to certain matters which are identical in the 06 statement, and they are identical with what we have now found in this material. The comparison of these matters, their confrontation, juxtaposition as we have edited it, this constitutes, we feel, a very important piece of corroborative evidence. Of course, what we have, even from the point of view of content, is self-identifying as a document from the accused. The material in its entirety, all we have here, relates to the activities of the accused in the period when he was in office on behalf of the Third Reich. It includes autobiographical elements of various kinds.
Judge Rave, the handwritten pages, can they be intertwined with a printed matter?
Yes, sir. The same subject. It is Eichmann's work.
Judge Rave, in a formal way, I inquire.
No, in the formal way, I do not think so.
Judge Rave, it seems that some 3 bands, as they are called, are missing.
5 tapes.
Is there any stop in the statement?
Every tape constitutes an exchange, a conversation about one subject. Sometimes they repeat themselves and even occur 3 times. There is no method, no connecting thread from beginning to end. I could not discover a method in these conversations which would, as it says there, this is the material on the basis of which Sassen and Eichmann were to have published a book about Eichmann's activities in the Third Reich. But there are certain passages where Eichmann says, this should be published only after my death, not during my lifetime.
Judge Halevi, is there any evidence when this was written?
Oh yes, there is a possibility of identifying the date quite precisely. It was compiled in 1956-57 because they speak about 12 or 13 years that have gone by since the end of the war. They take a position about a conference for Jewish studies in Jerusalem, and Eichmann expresses a comment about this. We know about the date of this conference in Jerusalem here. The conversations took place, as we see in the tapes and in the reprints themselves. They proceeded over a period of about 4 months. It was not one conversation, one contiguous conversation. They were different meetings. There are also comments by Eichmann in his own handwriting. What he called marginal notations. Sometimes the conversees here reserve space for a certain topic later on. The conversants. In the Bureau 06 tapes,
President of Court, Band, you mean at the head of each page you bring the number of this reel?
Yes, except for the first 2 pages, I believe, where it says AA. Now, if I may remind the court that in Eichmann's statement, there is reference to this matter. There are 2 references to this matter. On page 1391, may I obtain this, page 1391 of the transcript of the statement of the accused?
There are 2 places, we shall point them out in a minute, where in his statement to our police, he said that he already mentioned the subject discussed at Buenos Aires. This is in 3191. The page and the accused statement to Bureau 06. This is being read out by Mr. Hausner in the German and will be translated in a minute. He recalled that he discussed the matter at Buenos Aires. It seems to me that I spoke with the man also in Buenos Aires. This was the German passage. On page 397, I shall be grateful to the court if this quotation is examined, if it is the correct page number. Again in the German.
Und habe diese Sache zerpflickt in Anwesenheit von einem gewissen Herrn Sassen, der akkreditierter, wie sagt man hier, Journalist in der Regierung drüben war. זהו העמוד? כן, 3. תודה רבה. מה?
Now the quotation which was read by Mr. Hausner in the German. And I spoke once again to Mildner. This must have been some 3 years ago, and I explained the matter in the presence of a man named Sassen, who was, as it is called here, the accredited journalist of that government. We went into details, and on the basis of these details, the identification of the handwriting and the corrections, the general contents of the subject dealt with by the accused, C, the identification of many passages which during his investigation in Bureau 06 he repeats in the same style, sometimes in identical language, in what is found in these reprints. His reaction and comments of the accused to the article published in Life. He did not deny that this was part of the conversations he held, but said that they were not described correctly, not accurate. Also, because of the fact that all reprints deal with the actions of the accused, as has already become clear in this case, as he confessed himself, that his department 4B4 is mentioned there tens of times as my department. This is how he refers to this department. And I shall request the court, after all this has been proved to court, to admit the reprint in evidence that the material in our hands is this is an information, a statement made by the accused, admissible in evidence. This was not given before a man in authority, but outside the court. And inasmuch as this is so, I do not need to prove to court that this was done out of his own free will and not in result of any pressure. Judge Rave.
This is not based on paragraph 15 of the law for the punishment of Nazis and their collaborators?
I believe that I do not have to do so because of the material, the legal material in my hands. I do not have to apply to paragraph 15. The material is admissible as it is in our hands in any criminal case.
Do you believe that this is in accordance with paragraph 32/7?
Yes, this is a confession, not a confession, an information, a statement made not in court.
That the requirements of this paragraph had been complied with?
The accused made the statement.
Do you remember this paragraph?
Remember this clause in the law of
which
trial
is
by
very
information.
Clearly defined with regard to the statement of the accused.
Yes, of course. It says in that paragraph of the law that if the prosecution wishes to prove a statement made by an accused,
perhaps it would be advisable to compare the text, the contents.
Judge Rave refers to the order trial by information, not to the law of evidence.
Thank you very much.
Judge Rave, I believe it is paragraph 37(2) in brackets.
Yes, indeed. Yes, it is written. Those who heard or saw. I never thought that that particular paragraph is the only one, the unique one, which proves that the admission in writing is to be considered. If I take, for instance, an example a little far away from our case, when I, for instance, found notes and I could prove that these notes were made in his statement.
I believe that if such a sketch was found while a search was being conducted on the accused, then all I have to prove is the circumstances, how the sketch was found, and that will point to the fact that the sketch originated from the accused.
They would say this is not the only way of evidence.
This is what I try to maintain. This clause is not exhaustive.
Has it been examined whether there is some paragraph related to it? Any authority with regard to what has been said? Ask presiding judges.
President of Court, can you bring any precedents, Mr. Hausner? Judge Rave, maybe this should be re-examined.
Pisca is precedent?
Psica. Mr. Hausner, I believe there is. President of Court.
This is one of those paragraphs that had been neglected. They're extremely important, but yet somehow not adhered to.
I believe I can find precedents, but if the counsel for the defense has any objection to the submission of this document, we can save time if there is no objection. President of Court, will you show the paragraph to the counsel for the defense?
I'm not quite sure that this paragraph would be applied to the statement of a man before he is accused. Perhaps this is a paragraph which refers only to the accused that give their statements, for instance, at the police station. That means to say that not necessarily before the examining officer, interrogating officer.
Mr. Hausner, or the same way as conversations between prisoners are being proved to court. You mean after the man is already in jail and one of the other detainees reports of what he heard from the mouth of the accused? My question is whether Dr. Halevi refers to these cases.
I suppose that this refers to the statement of the accused at the police station. It is actually divided into two parts, namely oral statement and written statement, but all those oral and written statements of a man who has the status of an accused, and not a man who is accused today, but at the time of the statement, that the statement came after the implementation of the crime he is accused of, but before he had been accused of it. That means to say that